Kimberly Sullivan didn't show up in court today. She's the stepmom accused of holding her stepson captive for 20 years inside this Connecticut home. She's now out on bond. It's a controversial move by the court considering what she's accused of, a crime so allegedly heinous, members of law enforcement have said they've never seen anything like it. But Sullivan and her legal team want her conditions loosened even more, including getting her cell phone back, her GPS monitor removed, and the chance to return to the home where the alleged abuse took place for 2 decades. We're on the case presented by Law&Crime. I'm Chris Stewart. We have new information today on Kimberly Sullivan and the new efforts by her legal team to relax her bond conditions. Sullivan was arrested in March after police say she held her stepson captive for 20 years. All of this was uncovered when authorities responded to a house fire at Sullivan's home in February and found her outside.
Come on, come down, come down.
Come on down.
Who else is in the house? Who else is in here?
My stepson is in here.
How many other people?
Listen, that's it. I have 2 cats.
Everybody's out?
Yes.
But your stepson's still inside?
Yeah, he's right here.
Okay,
yes,
come out. Come down the road. Come on, come on. It's not safe to stay here. Come on.
All right, here he is. All right, my dog is shaking.
I know.
In the body cam video, you can see police carrying someone to an ambulance.
Got one victim right here.
That victim is a man who wants to be called S. He weighed less than 70 pounds when he was rescued. He released a statement last week. It was his first public statement saying he's doing better, but he's still recovering. And he also said he started that fire. He released this statement through an organization called Survivors Say. It said, quote, "I'm a survivor of more than 20 years of captivity and domestic abuse. I was held prisoner in my home from the time I was taken out of the 4th grade at age 11 until 2 months ago at the age of 31 when I purposely set a fire that helped set me free." Kimberly Sullivan was arrested weeks later on March 12th. She faces charges including assault in the 1st degree, kidnapping in the 2nd degree, and unlawful restraint in the 1st degree. This story is getting a ton of attention, and it starts, as you heard S say there in that statement, when he wasn't even 18, allegedly. And I will say that Kimberly Sullivan has pled not guilty, and she denies everything that she is being accused of. S says when he was 11, Sullivan pulled him out of public school, and really he fell through the cracks from there. He was not heard of, from what police have told us, since February of this year. Now, even though the school's administrators and teachers told the state of Connecticut they were concerned with S's treatment in school, after 2 visits by DCF, social workers didn't find enough problems in the home to warrant removing S from it. What S says was actually happening inside the home was Sullivan was keeping him locked in a room, sometimes for the entire day. She would allegedly only feed him small amounts of food. And in court documents, S told detectives some of his earliest memories were sneaking out of his room at night to get food and water. When it was found that he was doing that, he was locked in his room. He recalled drinking from a toilet because he would only get 2 cups of water a day. And that, according to court records, was just the beginning. Waterbury police released pictures that show some very disgusting conditions in the home. S says he kept track of the years by listening to NASCAR races and UConn basketball on a radio near his room. I want to take a moment and pause and bring you a Law&Crime legal alert. Did you know that children under the age of 21 are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease? And research is potentially linking ultra-processed foods to these outcomes. Our partners at Morgan & Morgan have a lot of experience in taking on major corporations. They're ready to hold food companies accountable and stand up for families who deserve justice. So if your child under the age of 21 has been diagnosed with one of those serious conditions like type 2 diabetes or non-alcoholic fatty liver disease, go to www.forthepeople.com/food, or you can scan the QR code on your screen. Initially, a judge gave Sullivan a $300,000 bond, which she posted, meaning she is not in custody. But there are conditions. We'll talk about that in just a moment. Then, ahead of Sullivan's March 28th court appearance, the state of Connecticut asked for tighter restrictions, arguing their case became stronger with additional witnesses coming forward. The state wanted house arrest and GPS monitoring. The judge opted against house arrest, but Sullivan is on a GPS tracking device. Today, Sullivan's case was back in court for a pretrial hearing. Sullivan waived her right to appear, so she wasn't there in person. The last time she was in court, her attorneys argued that stricter bond conditions were unfair. Her attorney said that Sullivan also has been the victim of threats.
There are serious safety concerns for her. If putting her in a specific area where she cannot leave will only create additional safety concerns. There are numerous threats against her. Numerous people have made threats. They're posting them online, talking about not waiting to be able to see her out in public. She needs to be able to have freedom of movement, and at times, in fact, Your Honor, I've actually advised her to leave the state initially, given the media attention, for her own safety. If the court was to put her on a GPS monitoring bracelet, she would not be able to do that. If the court put her on an EMS, she would not be able to leave the residence where she is. That would create additional safety concerns.
And when you see Sullivan not appearing today in court, does make you wonder, based on what her attorneys have said, how many more times we will see Sullivan appear in person in court ahead of a trial. Outside of court today, we heard from S's biological mom. She gave S up as an infant to his biological dad, who was married to Sullivan. Now, we know that the dad's name was Craig Sullivan. Police say he was in a wheelchair and he died in January 2024. S told detectives that his dad knew of his situation, as well as two half-sisters and his grandmother. That is according to court records. It is unclear what role that Craig allegedly played in this alleged abuse. S has not spoken about him much in court documents or in his public statement, as his half-siblings have not been charged. We know that S said that he got the lighter to set the flames that he says set him free from his dad before he died. Today outside of court, S's biological mom was asked whether she thinks S's biological dad played a role in this alleged abuse.
They could try all they want. They could try all they want. I mean, granted, was he a pushover? Yes. But the only thing that he did from me is keep my son from me. And as for him growing up and getting locked in a room from the time he was 3, and yes, it was 3, not 11. And he stated that already. They found rappers, and that's when they started. But it got worse when he turned 11.
As his biological family has said over the years, they tried to find him, but only could when his story broke in February. We also heard, once again, from Kimberly Sullivan's defense attorney, Ioannis Koloidis. He said that today's hearing was mostly about administrative issues of the case, and the state of Connecticut is still handing over discovery material as he prepares to defend Sullivan in court. He confirmed that his defense has filed a motion to get Sullivan her cell phone back, which he anticipates will happen later this week. He also spoke about making a change to a protective order that restricts Sullivan from going back to the home where the alleged abuse happened. He said he expects that to be addressed at Sullivan's next court date in May, and whether she would live in that house, he said, is yet to be determined. He also said Sullivan's defense is appealing the judge's decision to put her on that GPS tracking device. He also, once again, said that Sullivan is innocent of everything she's accused of.
My client has done nothing wrong. She is adamant that she is innocent, and she is innocent of anything until a jury decides otherwise.
He has made several arguments around his perception that people have already convicted Sullivan in the court of public opinion.
One of our concerns is making sure our client gets a fair trial. So obviously we pay attention to what's being reported and how it's being reported and how she's being portrayed in the media. Obviously we have some concerns. Some media outlets have used very inflammatory language, have already convicted her, and that's obviously a problem. So we're obviously going to push back on that. But when the time comes, we're going to try and find jurors that can be fair and impartial, and jurors that have not made up their mind based on the limited information they've been provided.
The alleged victim in this case, that man who wants to go by S, did not mention Sullivan by name in his first public statement, but he did say this, quote, "I ask everyone involved in my story to fully cooperate with the authorities who are helping me seek justice for these crimes. I also ask the public and the media to respect those investigations and my privacy as this process plays out. This isn't just a story, it's my life." And here's the statement that Sullivan's attorney sent us in in response to what S had to say. Quote, "The worst thing that can happen to a human being in this life is to be the victim of a heinous crime. Nearly its equivalent is the horror of being falsely accused. It makes the accused an object of hate, who is disparaged and cast from society. It provokes a lynch mob mentality. The accuser's public narrative put forth by his handlers lacks both specifics and credibility. It appears timed to sway public opinion, and its only purpose can be to poison the well of a future jury panel rather than seek justice through proper legal channels. As Miss Sullivan's attorney, I am obliged to denounce it as an unsavory tactic filled with half lies and distorted facts, prejudice wielded like a weapon, a rush to judgment prioritized over truth." And at the end of his remarks today, Sullivan's lawyer was asked this about Sullivan and her stepson's relationship from her perspective.
Does she love her stepson?
Sure she does.
Joining us now to talk more about this case is criminal defense attorney and civil rights attorney Tyler Bailey. Thank you for taking the time to be with us today. When you look at the allegations, and they are just allegations that Kimberly Sullivan is facing in this case, as a defense attorney, what stands out to you about the approach that her defense appears to be taking thus far?
Well, her defense is taking a very aggressive approach. They're not shying away from the media. They are trying to make sure the prosecution crosses their T's and dots all their I's. And even if they're dotting their I's, they want to make sure it's bolded. They are challenging everything. You know, you see from the bond hearing to now asking for her phone back. The defense team is really putting on an aggressive case, not simply trying to defend the case, but set the tone themselves.
There are some attorneys that would try this case specifically just in the courtroom. They wouldn't make a lot of statements publicly. That is not the approach, to your point, that this defense team is taking. Ultimately, when you do that as a defense attorney, what is your goal in terms of how it could eventually lead to the outcome you want in court?
Well, at the end of the day, every defense lawyer's goal should be to have your client, who's the accused, have a fair day in trial. You know, that there's an impartial jury, that they have an opportunity to present their defense, and that the prosecution is forced to try to prove their case beyond a reasonable doubt. And a case like this, has such high profile and has the eyes and ears of people not just in that community, but the country. A lot of defense lawyers sometimes shy away from the media, but there are others who want to help shape the thoughts and minds of potential jurors. They also want to make sure that they are representing their client, not just in the courtroom, but also in the court of public opinion.
What stands out to you about the evidence thus far that the state and the police have put forward against Kimberly Sullivan?
Well, it's very damning circumstantial evidence. The gravity of those photographs that have been released in the media are terrible, to say the least. The living conditions where this victim was allegedly staying are heinous. And so, I mean, those images do not help the accused. And some people may be also just looking at her demeanor in the courtroom during the hearings, and they're probably making their own opinion now, not just all based off the evidence, but what they're seeing of the actual defendant. So the evidence, I think, is not looking good against the, for the defense, but it's still circumstantial. There's no direct evidence outside of the victim setting fire to where he was staying to free himself and his testimony. So it's a defendable case, but it's all going to be about what those jurors in that courtroom will believe when this case does go to trial, if it does go to trial.
Right, because one of the big pieces of evidence, and I presume he won't weigh this much eventually when they get to a trial, is S, who's the stepson. That's the name that he wants to go by now, that he weighed 68 pounds. That's kind of the headline number out of this case. For him, I mean, he is the piece of evidence in many ways. I mean, how important is that number really? Because that was the shocking number for me when this story first broke, was how is someone who's 32 years old under the weight of 70 pounds?
It's a very strong piece of evidence for the prosecution, and probably what will be even stronger is the medical examiners and those doctors, the immediate, responding emergency personnel, their eyewitness recount of what he looked like. That description, in conjunction with documented medical evidence of his actual weight of being 68 pounds as a grown man, is strong evidence. And another piece of evidence I really do think is strong for the prosecution is this alleged friend of the accused who allegedly said that she's known her for years, but she never knew about the stepson. It's those pieces of evidence right there that really support the prosecution's case.
And in terms of the weight, because we had this arrest affidavit from police and it lays out this story from S about everything that he went through. And then you have the pictures. But ultimately, too, I'm sure there are going to be medical records that the state's going to put forward. And we've heard about his teeth were decaying, that his hair was falling out, that he was under the weight of 70 pounds. From the defense's point of view, do you get a medical expert on your own who might testify in a way that could be favorable to your defendant? And what type of access, knowing that S is a piece of evidence himself, what type of access could the defense have to the victim ahead of trial?
Well, the thing that's always important to understand is that the defense doesn't have to put up any evidence. It's the prosecution that needs to put up the evidence to prove their case beyond a reasonable doubt. If the defense does decide to get an expert of their own, I don't think that would be the most beneficial, because you're going to have a battle of the experts, and experts could say one thing or the other, but regular folks will make their own opinion by their own eyes, their own ears, what they hear, what they see. And so if the images of the victim show decaying teeth, losing of one's hair, 68 pounds, having an expert for the defense try to point towards some other reason outside of the room that looked like it was deplorable and he could not get out of, and it was tiny, would be like trying to pull wool skin, over their eyes here. So I don't think that's the best idea. And the defense should have opportunity to review every piece of evidence that could be used against the accused in the trial of this case. So if there are going to be witnesses that are going to be put forth, the defense will have an idea what an expert witness will testify to. They'll get an opportunity to review their CV and get an idea about their opinions. They also be able to review every piece of medical evidence, photographs, witness statements, and things of that nature. So they'll have an opportunity to get an idea how they could try to address the evidence that the prosecution may see to bring forward.
We are a long way away, likely, from this case if it does go to trial. But if you have this moment where S takes the stand and he tells his story and the allegations against Kimberly Sullivan, if you were her defense attorney, how do you go about your line of questioning and a cross-examination where you get the information that you want, but then at the same time, if you have jurors who are sympathetic to this person who is in such a bad physical state, that you don't cross the line in a way that that could end up hurting you and making the victim look even more so favorable to the jury?
Well, you'll have to be very careful of how you cross-examine S if S does take the stand, if you even cross-examine S at all. Cases are like a basketball game. It's a game time decision. I think that you would look at, if I was defending the accused here, Kimberly Sullivan, I would look at trying to attack every piece of evidence that the prosecution brings forward. More so trying to point to either a sloppy investigation, that the prosecution immediately zeroed in on their theme and idea of how this could have occurred. And then if S does take the stand, see where you could score points for the defense if you can, because automatically the jury will be sympathetic to him. Even if, let's say, he suffered some other, whether it's mental or physical disability or ability that kind of restricted him to that area, that still is something that will be sympathetic. The judge would be sympathetic to. So even if that is the defense, that he had the ability to leave, but due to his own personal reasons, he decided to be recluse, I don't think the jurors will take too kindly of an overly aggressive defense attorney really attacking a witness like that who's had to suffer so much to get to this point where we are today.
Because on the flip side of that, S, from what we understand, we know he hasn't been in public school since the age of 11 when he was pulled out. I don't know what type of education he had while he was inside the home. We'll never hear from his biological father because he passed in January 2024. But assuming that he doesn't have the education level that most people would have at the age of 32 years old. How do you prepare a witness like that for what could be a hostile environment where you're going to have a defense attorney who's going to try to score points to help the person you're accusing of a crime that we've had police officers say is something that they've never seen before?
Well, if you did not have such strong circumstantial evidence, I'll be more cautious as the prosecution of putting S on the stand. But the circumstantial evidence is already very strong just by the nature of those images, and the medical evidence appears to be very strong as well. So S will really be bringing the story home for the jury to let them know, how his life started off, how his childhood was. When did he start being confined to this area? What was he fed, to kind of back up the medical evidence that leads the jury to believe that this was because he was barely being fed, he was rationed food, versus having some other medical condition. So I do think it would be important for S to testify because he's ultimately going to bring everything home. The circumstantial evidence would lead one to believe that this is the reason as to why he's in that condition, but him testifying would be strong evidence to try to close that link. And that being said, because of the circumstantial evidence, I think that the prosecution, even if he got crushed on cross-examination, I don't think S will be the one to actually tank the case here.
When you're in a case like this where there is a lot of circumstantial evidence and you may be able to argue, I've seen her attorney say in interviews because there were locks on the outside of the door. Well, those locks were there prior to her moving in. Allegations that have been made about the home. He'll say those pictures were released without much context. The kitchen, as you can see, it is stocked, that there's food items in there. He has said, where are the chains in the house? We know that he'll argue that this victim could have just walked out at any time. But at what point does the circumstantial evidence add up to where you can only explain away so much, and to a jury, eventually it just seems, even if you're not having that smoking gun that ties someone to a particular crime, that circumstantial evidence, how do you battle that when it's really just a mound of circumstantial evidence that they're going to have to push back against?
Well, the best way as a defense attorney, when a case is largely based off of circumstantial evidence, is not just attacking the circumstantial evidence and what ifs, but also, trying to score points about the prosecutions and the investigating officers and how they zeroed in on the defendant, and that being Ms. Sullivan here. Let's say they could have talked to other people to see about, the house beforehand, or whether the child or S was fed. Really trying to show that the investigation was shoddy, that they zeroed in on Ms. Sullivan here, and that they automatically concluded that she must have kept him captive all this time when there could have been another reason for doing so. But when the circumstantial evidence is just overwhelming, sometimes it looks like the defense is trying to trick the jury into believing something else. And that's not what you want to do. The best way to do it is really show how the prosecution and the officer's investigation was flawed. And because it's flawed, how can they now believe that everything is in line with the presentation that they're presenting before them that day or that week of the trial?
Another big part of this story has been Kimberly Sullivan being able to post bond. The original judge that she saw after she was arrested, she had bond of $300,000. She was able to post that, so she is free of custody right now, though is on a GPS tracking device. And so it's not, that she's completely walking free. She is being tracked, but she's not behind bars. What do you make of that decision for the judge to set it at a level that she would be able to meet to get out?
I think the bond was pretty low for the facts here. And I've seen cases with drug dealers who've had higher bonds than she has had. And I do understand that, everybody has a right to bail under our United States Constitution. And the judge who heard this case would have heard the facts and what the accused is accused of committing, and weighed that with factors like whether she's a flight risk, a danger to society, her ties to the community. And he found fit that bond was sufficient to secure her release and ensure that she will participate in the prosecution of the case. But I do think it was low. I'm surprised that it was also reduced to $300,000. The GPS monitor does help, But it does seem like she's going to be participating in the trial so far. Usually, when somebody's accused of heinous crimes and you have a situation like this, I assume and I would think $1 million bond or bond being denied is what the court would set. But here, the bond was, I believe, a reasonable bond for her to post. The judge found that bond to be sufficient, but there's clearly public scrutiny on that choice just by the nature of the case.
In experience with your cases when it comes to bond, her attorneys have filed a motion for her to get her cell phone back. They believe that she'll be able to get that by the end of the week. What type of I guess I'm not even sure the right word, things that she should be able to have as she's out on bond with the GPS monitor? Is a cell phone something that in this day and age that someone should be able to have as they're awaiting trial and out on bond?
If they believe that the cell phone contains evidence of the alleged crime, I don't see how a judge orders that she can get her cell phone back. I mean, she could still have access to her cellular plan. She can get a new phone. And just by nature of prosecuting this case, you'll need to have chain of custody. And generally, you'll see things like cell phones that are in bags, and then you'll have a records custodian or somebody testify that this is the device that they extracted, whether it's location data, text messages, cellular data from. So I think the defense asking for the cell phone back is really showing their aggressive demeanor about how they're approaching this case. I mean, just think about it. She did get a high bond, but they're pushed for a lower bond. Her phone is taken. She's asking for her phone back. It's clear they're not trying to suck up to the prosecution here. They're saying this woman is innocent. She deserves to have her case heard by a jury, and they're demanding everything they believe she's entitled to, which is a very aggressive approach with the facts that are in front of them. A lot of times in a case like this, you'll have defense lawyers who may say, hey, due to the heinous allegations, we're going to kind of try to fly underneath the radar. Let's not request additional hearings if we don't have to. Let's see if the public will forget about this case, and by the time it comes up, maybe that may be a more favorable plea offer that's given to the defendant by them kind of just cooperating and being compliant while they're out of bond. But that's not what we're seeing here from this defense lawyer. I think that he has his own strategy and his reasons for doing this, and it's a different approach. This is a similar type of approach that was taken in the O.J. Simpson trial, where they are pushing the envelope here. It's called, they're defense lawyers, but they're playing offense on a lot of fronts right now at the pretrial stages.
What's the relationship typically like when you have a defense that's playing offense with the prosecution?
It can get very adversarial. The prosecution a lot of times will think the defense lawyer is just doing the most here, and that's not standard, that they know that this phone will probably be needed for chain of custody evidence in the trial of the case, and there's other avenues for the accused to still have access to a cell phone. If it's an iPhone, she should still have access to iMessage or things like that. And so they'll think that the defense lawyer is either one, just kind of taking a controversial approach. They're probably going to think that the defense lawyer is just trying to have the case in front of the cameras, to try the case in front of the cameras or draw more media attention to it. But, it's an adversarial profession that we're in. At the end of the day, you have to zealously represent your client who's accused in the situation. And their job is not to cozy up to the prosecution. It's to do everything that they can under that's legal, whether it's in the courtroom or the court of public opinion, to advocate for their client in a way that things will be beneficial for her in this situation.
Yeah, and we're certainly seeing them take that approach thus far, but a long way to go in this story. Tyler Bailey, always great to have you on Law and Crime. Thanks for taking the time to be with us. We appreciate it.
Thank you.
Sullivan's case is expected next in court May 27th. For On the Case, presented by Law and Crime, I'm Chris Stewart. We'll see you next time.